Oral argument started with Mr. Zelinsky, attorney for Ms. Janice Hughes Barnes in the estate of her late son, Ashton.
Mr. Chief Justice, and may it please the Court, we are here today because Ashton Barnes was shot and killed on the side of a Texas highway after being pulled over for unpaid tolls. The question before this Court is how to determine whether Ashton's Fourth Amendment rights were violated. The Fourth Amendment prohibits unreasonable seizures. Justice Scalia was no fan of a totality of the circumstances test. But in Scott, Justice Scalia made clear that courts must slosh through the fact-bound morass of reasonableness. In this case, the District Court and the Fifth Circuit didn't do that. Instead, they applied the moment of the threat doctrine. According to the Fifth Circuit decision below, quote, "We may only ask whether Officer Felix was in danger at the moment of the threat," and, quote, "any of the officer's actions leading up to the shooting are not relevant." This kind of legal amnesia is incompatible with precedent, conflicts with common law, and defies common sense.
How do we determine if Officer Felix's actions were reasonable? Was it simply that at the instant he started shooting, his life was in danger? Or should the courts consider the officer's actions, including jumping onto the sill of the vehicle, when it considers the reasonableness of his actions? The two doctrines the court talks about are moment of threat and totality of the circumstances. The Fifth Circuit applied the moment of threat doctrine, meaning they gave no consideration to how Officer Felix's actions may have contributed to the threat he felt at the time he used lethal force. While both the district and circuit courts found the actions of Officer Felix reasonable, at least one of the judges wrote in his concurrence that the officer acted unreasonably.
Finally, as Judge Higginbotham underscored in his concurrence, the facts show that Officer Felix acted unreasonably. But this is a court of review, not of first view. The court should rule for petitioner on the sole question presented and remand for the lower courts to apply the correct constitutional standard. I welcome this court's questions.
Now, after his opening statement, Mr. Zelinsky answered questions from the justices.
Under your approach, what would that correct standard look like, and how would it be applied here?
Justice Thomas, we think the standard is the totality of the circumstances standard that this court articulated in Graham, and Garner, Scott, and Plumhoff. In this particular case, it would require looking at more than just the 2 seconds in which Officer Felix was on the moving vehicle. It would require asking, was there a reason for Officer Felix?
You will find this 2-second rule referred to often in this case. It's related to the time frame in which Officer Felix jumped onto the moving vehicle and him discharging his weapon. Do you only consider the situation when Officer Felix is standing on the vehicle, or the situation that put him there?
How much more than the last 2 seconds?
Justice Thomas, if you include an extra 3 seconds, then you would look at the seizure in its totality. I think that this court shouldn't be drawing bright-line rules on exactly how much of the seizure should or shouldn't come in. That's what Justice Scalia underscored in Scott. There are no rigid rules, and courts can apply ordinary principles of relevancy and proximate cause to determine the reasonableness of a seizure.
So the plaintiffs weren't looking for a bright-line rule, meaning you can look back 2 seconds, or 5, or 10, or 30, etc. Rather, they wanted the courts to look at the relevancy and proximity of the cause to determine if the action of the law enforcement was relevant.
Was it reasonable for the officer to jump on the side of the car?
So, Justice Kavanaugh, we don't think it was in this particular case, but that's precisely the issue that the lower courts couldn't evaluate, because they applied this legal amnesia and only look at the fact that the officer was on the moving vehicle. Judge Higginbotham, in his concurrence, looked at the totality of the circumstances and said, I think it was unreasonable in this case. We want the opportunity for a court to be able to look at that and for us to be able to litigate that court claim.
I noticed during oral argument that justices frequently detoured from the question at hand. Should the court have used the moment of threat or the totality of circumstance standard to evaluate the reasonableness of the officer's actions? It seems the justices were very interested in whether or not Officer Felix's actions were reasonable. Mr. Zelinsky was not the only person to attempt to bring the justices back to the question at hand. This really isn't a surprise, since the topic of what is reasonable is so often argued in court.
The reason for the question is to probe whether you are using the term unreasonable in a sense that's different from the sense in which the Fourth Amendment prohibits unreasonable searches and seizures. So unreasonable has a particular meaning when the court has to decide whether there was a Fourth Amendment violation. But in lay speech, unreasonable could go to whether the action was prudent, whether it was a violation of best police practices or the practices of a particular police department. Those are not necessarily the same thing. In fact, it seems that they're probably different. So you are eliding these two different meanings of reasonable. Now, maybe that's sound, maybe that's unsound.
Justice Alito, what we're asking for is the standard that this court has applied in Garner, Graham, and Scott and Plumhoff, which is you have to look at the balance here. There's on the one side the state interest in seizing someone in a particular manner. On the other side, there's the harm to the suspect. Here, the ultimate harm, the loss of his life. The problem in this case is that the Fifth Circuit couldn't engage in that core balancing because it couldn't ask, was there a really pressing reason for an officer to jump onto a car and give himself no other opportunity but to shoot the driver?
Was it reasonable for the officer to jump on the sill of the car or not? Did Officer Felix take an otherwise simple traffic stop and escalate it by putting himself in a situation where deadly force was the only option? Well, that is a very interesting question. The argument Mr. Zelinsky is making is that the Fifth Circuit could not ask this question because they felt bound to the moment of threat doctrine.
Well, would you be satisfied with a narrow holding that it is wrong for a court to look just at the moment of the threat, that the court has to judge the reasonableness of the alleged unreasonable seizure based on taking into account, to whatever extent they are relevant, the events that occurred before that? Would you be satisfied if we just did that?
I think we would.
Not get into these other more difficult questions.
100%. I think it would be helpful if the court makes clear that that means that you can look at the jump in addition to the shoot, right? That's the core issue that we want to be able to litigate. But yes, Justice Alito, we'd be happy with a very narrow holding.
All Mr. Zelinsky and his clients were asking for was an instruction from the Supreme Court that only looking at the moment of threat was not sufficient for determining reasonableness. Other attorneys would make grander claims, but they just wanted the circuit court's decision vacated and remanded to be decided on more than just the moment of threat.
I think you've given up in your reply brief, I understood, that you're not asking us to address the question of what an officer-created danger rule is like.
We're not asking for an officer-created danger test at all.
And that wasn't even addressed below, correct?
That's correct.
Okay.
One of the oft-repeated points was a question of officer-created danger, meaning that if the officer created the danger, it was not reasonable for him to use said danger as justification for the use of force. But isn't that the exact same standard used in every state law regarding the use of lethal force in self-defense? If I cannot create a dangerous situation, then claim self-defense, why should law enforcement? As I said, the justices spent a lot of time on the question of reasonableness rather than the standard for determining reasonableness, which led to this interchange between Justice Kavanaugh and Mr. Zelinsky.
When an officer jumps on the car, the deadly force can be avoided by the driver, too.
Well, in this particular case, Officer Felix's own expert testifies that Officer Felix shot so quickly, Ashton Barnes didn't have time to stop. And if I could, let me sketch out, Justice Kavanaugh, why it's so dangerous for you to shoot a driver. In fact, I'm not aware of any police department that recommends that its officers shoot drivers. The high likelihood, in this particular case, Ashton Barnes didn't immediately die. He was able to brake the car and put it into park. If he had been immediately killed, that car could have careened and crashed into the highway. Officer Felix put other people on that highway in grave, very serious danger that particular day. So I don't think it's just he's jumping on to stop Ashton from getting away. He's also jumping on in a manner that is going to put a lot of other people at risk.
Again, not germane to the topic before the court, but an interesting question. Is it reasonable to shoot the driver of a moving motor vehicle? I'm sure there are times when it is, but this seems to not only be an escalation against Mr. Barnes, but a threat to the public at large. Based on research that Mr. Zelinsky brought, jumping on a moving vehicle isn't the only dangerous action repeatedly taken by law enforcement.
The other reoccurring fact pattern is a pattern where officers fail to identify themselves. and the suspect, exercising his or her own Second Amendment rights to self-defense, pulls out a firearm. The Fifth Circuit alone has 2 cases in which they apply the moment of the threat doctrine. The cases are Cass and Royal, and they say, we can't look at the fact that the officer failed to identify himself. We can only look at the fact that the officer faced a loaded gun.
Imagine someone comes to your door or your vehicle or just stops you on the street. Maybe they're armed. Maybe they're just demanding information or that you take a certain action. This could easily be seen as a threat, leading you to defend yourself by showing or possibly drawing your firearm. Since it appears most law enforcement is trained to draw and prepare to fire at the word gun, this could easily end up badly for you. Now imagine the court only looks at the fact that the unidentified officer saw a firearm and not the fact that the officer initiated, even escalated the situation to one of deadly impact. That's what we're talking about here.
What do you do with the cases cited by the other side where the Fifth Circuit does appear not to apply the moment of threat doctrine and does take into account more of the totality of circumstances?
So, Justice Sotomayor, let me give you 3 responses. First, there's never a Fifth Circuit case where they actually look at the officer's prior conduct and say, that's part of the calculus and it goes against the officer. So it's always, whenever they might do it, it's only in the officer's benefit. The second, the best case...
Some of my colleagues might agree with that. Why should we not?
Because you have to look reasonableness. The framers gave us a test of reasonableness, and that is it's a 2-way street, not a 1-way ratchet.
In the Fifth Circuit, there has never been a case determined by totality of the circumstances that did not benefit the officer. And Justice Sotomayor asked why her colleagues shouldn't agree with that. Are you telling me that law enforcement has never escalated a situation into the use of force? Or does Justice Sotomayor believe her colleagues agree with her that law enforcement is never responsible for the use of force, even if they've initiated the situation that led to it?